Yes, ma'am.
My lord, let the matter be listed tomorrow, my lord. Actually, it was listed on Friday, but it become leftover. That's why I need tomorrow.
Matter relates to which bands?
Division bands, police, atrocity, my lord. Highly obliged.
When did you file?
Long back, my lord. It was already been listed on Friday, but it was leftover.
Okay.
Highly obliged.
Lordship, my case may have taken 5/20/20.
From this side.
My case may have taken 5/20/25 not been listed. Let the case be listed on 11th of April.
Not on 11th, ma'am. Either after view vacation, because 10th, 11th, these two matters, only the motion will be taken up. So there will be no much time for hearing of the matter. So either immediately after view vacation, whether you want on 22nd,
4th April.
4th April. Right, 4th April.
Most obliged.
Sir, I need to mention item number 6, Lordship.
Hmm.
Sir, Lordship, today actually, Lordship, I could not prepare this case, Lordship, because of the Lordship. Lordship, can it be Lordship after 2 weeks, Lordship, or any other? Matter is a heavy matter, both long matter. Lordship.
Let the matter reach. You want after vacation? We'll
Maybe,
consider.
Lordship, vacation, Lordship.
Let the matter reach first.
Oh, Lordship.
With his Lordship, Lordship, I beg to mention item number 2, Lordship.
Hmm.
Kindly the matter may be adjourned only for the day, Lordship.
Why? Why do you want for the?
Lordship, my senior, he has some difficulties, Lordship.
Okay, let the matter reach.
Obliged, Lordship.
Hey, please, Lordship. Lordship, I beg to mention for listing of a criminal appeal, Lordship. Lordship, it was listed today before the special division bench, Lordship. Lordship, we fix before
To be fixed?
vacation, Lordship. Lordship,
When do you want to be fixed?
before vacation, Lordship.
Before vacation?
There is urgency, Lordship.
What is the urgency? Tell us.
Lordship, he is behind bar and he is an aged person, Lordship, and medical report is also received. His health is deteriorating day by
He's
day.
suffering from what?
Lordship,
He is suffering from what?
no such thing.
Is there anything that he has not been provided with him medical treatment by the jail doctor or anything like that?
Lordship, the opposite party has told that the medical report is issued.
Medical urgency meaning to us. Let's try to come.
Before Lordship, if possible.
Court.
4th April. Published.
Yes.
Here, my lord, we have five also IA for bail, my lord. The petitioner is on, is in detention camp, my lord, since 6/3/2025.
Please take your seat.
My lord.
For the first time, name of your projected father figured in a voter list of 1985 at the age of 43.
My lord, there is
Whether the existence of your projected father prior to 1971.
my lord.
Kindly tell us whether your projected father was in India prior to 1971.
My lord, he was born in 1961. He was born in 1961.
He was born in 1961. For the first time, the name of your projected father figured at the
85.
age of 41 in the voter list of 1985.
My lord, there is some mistake, my lord, in the age, my lord.
You are relying on those voter list.
But
We cannot
subsequent,
pick and choose something
in subsequent voter list, it is correct.
that is in subsequent.
My lord.
You are relying in the voter list of 1985 to show your connection with your father as well as your grandfather.
My lord, there are other voter list also, my lord.
That is why I'm asking you.
In subsequent voter list, the A's are.
That cannot be, because you have to show the existence of your father. Had there been the name of your father figured prior to 1985, you could have been a different list altogether.
In 1997 also, you know,
These are subsequent.
subsequent. My lord, my share, my lord, at this stage, my lord.
Why? Because why should you interfere at this stage unless you show the illegality in the order?
Even my lord, in the inquiry report, my lord.
It is your case to prove everything. That is why kindly tell us. We'll definitely consider your prayer if you can establish your case.
My lord,
To grant you some interim prayer, you have to establish your case.
another, another prayer is, my lord, the inquiry, my lord, and the forwarding report.
Whether
It never says then after 1971. It is beyond the reference, my lord, opinion.
where is your written statement?
That is space, my lord. 61.
What happened from 1970 to 1985? What happened? How these voter lists have been proved?
My lord, these voter list, my lord, initially, my lord, it was not.
How these voter lists have been proved before the tribunal?
Lord, the 1985, my lord, and some other voter list also not proved, not proved, certified copy was not proved, my lord, submitted. Thereafter, the petition also filed a review along with the certified copy, my lord. Review petition, but that has been received. My lord, due to, my lord, the learned advocate, my lord,
Which are the certified copies you have produced during the time of review?
my lord, this certified copy, my lord, that is page,
Voter list.
page, 114 or 144, 85.
It's a certified copy.
The digitally signed, my lord.
Kindly read. English translation of Assamese version of certified electoral roll. What is the value in evidence? When it is a translated copy? How do you need to prove it?
My lord, it, in terms of our High Court order, my lord, it is acceptable, my lord. Then other certificate copy also I have submitted that is space, my lord. Uh, That is page 152, my lord, 153. 153. Then my lord, 157. These are 30%, 153, 157, and 159.
So in the year 1985, you were 43 years old. 1989, 43 years old.
That
And
is,
in the year 1994, you're 43 years old.
my lord, that is mistake.
Page number 154 or page number 156.
My lord,
Which village?
page number one
Page
sixty-three.
number 157. Kindly tell us from which village?
My
Because
lord,
page number
they have
154 is
shifted.
not the certified copy.
Initially, my lord, after 2000, they have shifted from Dhubri district.
Kindly tell us, because name of the petitioner, the procedure figured along with his projected further in the first time in the voter list of 2010. From which village?
My lord, that is from Kholisha Vita, my lord. Kholisha Vita, Hindu Para.
It's a part only.
My lord. Earlier, they were in Dhubri district, my lord. That is, in 2000, they have their father shifted, my lord.
In the written statement, in which paragraph you have mentioned that?
My lord, in written statement, it is not mentioned. But my lord, in prose, they have stated.
Doesn't matter if you have not stated in the written statement, you cannot take up that issue later on.
My lord, in cross examination, my lord, kindly peruse, my lord, cross examination, page 96. Page 97, my lord.
Yes, Mr. Sharma, what do you have?
Lordship, this is record may be called for Lordship regarding interim. Lordship will consider after receipt of the record Lordship.
But
And
Mr. M.R. Conductor, counsel is hearing for the petition. Who is appearing for Union of India? Is there anyone? No.
all Lordship.
No representation on behalf of the plus one number one agency. You are appearing? Mr. H. Kuli, standing counsel, on behalf of Mr. K.I. Ali, standing counsel, election commission for the response number two. Mr. P. Sharma. Additional senior government worker Assam, for the response number three. And 3, 9 and 10. Mr. G. Sharma, standing counsel. Home and Political Department of the State for the response number 4, 6, 7, 8. And 8.
5 also Lordship.
As well as standing counsel home and political, as well as static counsel and also for the rest of the first 3, 4, 5, 8. And Mr. Kalita, you are appearing or who is appearing?
He is appearing Lordship.
No, for ERO you will represent?
Yes, Lordship, he will represent.
H. Kuli. On behalf of Mr. A.L. for response number 11 and 12. Very input opinion. There is 06032025. Path well on its furnace tribe on its Kamrup Metro. FT number 2. In FT case number 700/2015. Appoint the petitioner to be a foreigner. Of post 24/03/1971. Who are illegally entered into territory of India from the specified territory without any valid documents from the specified territory of Bangladesh. The petitioner agrees with said opinion. Preferred. Review petition. Under section 33A within bracket 2 of the foreigners in bracket tribunal's bracket close order 1964. The said tribunal by its order dated 21/03/2025 rejected the review of the order dated 06/03/2025. Passed it. Said application number 700 of 2025. Aggrieved. The petitioner has filed this writ petition on 28/03/2025. Along with by its 7968 of 2025. Praying for interim. Call for the records of application number 700. Public 2015. Along with the order is 21062025 in original from the office of the furnace tribunal, Kamruk Metro, number 2, Guwahati. List on. Twenty-ninth of April. Interim prayer of the petitioner shall be considered on perusal of the records. This order be brought to the notice of the register. On more sentence 3, this copy will be read. List record.
My lord, so may I lay on 22, my lord, 22.
See if it can come, okay, make it on 24th instead of 20.
I am deeply.
Yes, Mr. Rashid.
Mal. Evening, been order Excel 5, page 30, 35. First minute. In your notices issued, I appeared there, I filed a statement, my brother also filed evidence, and on Gaura's not examined. And total list of 1966 of my father, 70 also given. And some land documents, some. Copy of Java, etc. And now we not page 30 is the imprint order. And it was no problem on 25th, sorry, 14th January, February, LCR was called for. And probably LCR has come.
Please take your seat, Mr. Seth.
Well,
Yes, you relied on what? You relied on what, Mr. Asid?
10 million, voter list of 1966,
1966.
fathers, 70, fathers below. And also,
70 is a certified copy.
70, not pages, 38. No, Milord. Let me not, what's it copy, yes. Then Milord, Daura certificate.
After 1970,
1970, Milord,
next voter list,
Negro 89.
89 or 97. Or you have explained from 1970 to 1997 of Tonu Mia, your projected father.
But 89 is the father, mother, and brothers, Milord, and
It
in
is
the
not
same-
there in the evidence. You have exhibited 1970 voter list of your father.
Hmm.
Then exhibited 1997.
my lord.
Then your voter list of 1993 showing your age as 28.
And 89 also, my name is there with my husband. And in the same voter list, my lord, my father name also there, my lord. When I was married in the same village. And in job only, my lord,
Have you exhibited that voter list before the tribunal?
that, my lord, 89.
Yeah.
89, my lord, yes, let me see.
Exhibit করেছে না নাই হইছে
No, which.
নাই করা
বুঝি পাইছো? No, only 93 was exhibited, my lord, yes, your lordship. But 97, that is 97 also exhibited. 89 was not exhibited.
97 is not your certified copy.
The 97 also for fathers. Sorry.
So what is the link document?
Here is my Gavra certificate,
Gambura certificate.
my lord. Gavra certificate,
How
that
you
is,
have proved that Gambura certificate?
he approved, my lord, he approved. He appeared and deposed.
Hmm?
Yes, in Gavra appeared, my lord. Gavra is a DW, my lord.
Hmm.
DW 3, my lord.
Hmm.
Page 28, 29.
Yes.
Married, my lord.
Yes. Can you read?
Man. Page 28, my lord, and except 4. I am the Gavra of Karatol, Gazia, Baganga, Rangapani. In our relative Rangapani. I know the second party Bilaton Nessa. Her father's name is Tunumia. Second party's father expired about 4 years ago. Second party's mother name is Asia Khatun. Second party was born at village Rangapani and married at village Rangapani. Her husband's name is Kurpan Ali. I gave the exhibit on certificate exhibit on is my signature. In cross, my lords, I became governor in the month of December 2015. Population of the village will be about 24,000. I am maintaining register from February 2018. I know that second party for about 6-7 years, and her father about 10 years. I have issued certificate on verifying total list of 1966 and 70 and 97.
So,
I have not. It is not a fact that I have deposed falsely.
so on the voter list of you are not
66, 70 and 97.
1997.
My lord.
So whether 1997 voter list was exhibited?
Yes, my lord.
Hmm? Whether it was exhibited before the tribunal? Was it a certified copy?
Only 93 was exhibited, my lord. Not, yes, 97 was exhibited, my lord. That was my exhibit C. In
Exhibit
the,
C, are you sure?
my lord. Exhibit C, my lord, 1997 voter list. That is in the record, my lord, your lordship may frequently see. And 1993 voter list, exhibit E.
Where is your link document? That is the link document.
Only Gavra certificate is now, my lord, issued.
Now, where is the continuity after 70?
70, 97.
In between 70 and 97, what happened?
And land revenue receipts usually deposited, my lord, but those are, my lord, denied by the court, my lord, because there was no proof that we are residing on the same land till date. Father was residing, so that was rejected. And on the same land, my lord, there is a only was subsequently issued, and that was next year, my lord.
Kindly read the impugned opinion at page 30. Come to paragraph 6.
Well. Proceeding Vilatun Nessa in her written statement stated that she is a bona fide citizen of India, born and brought up at village Rangapani, Mauja, Jonia, PS district, Borpata. Proceeding stated that her father, namely Kanumia, and his name appeared in the voter list of 1966 at village Rangapani under 51 number Dunia LC. Proceeding stated that her father name also appeared in the voter list of 1997 at village Rangapani under 44 number Dunia LC. Proceeding stated that her name enrolled in the voter list of 1993 and 1997 at village Rangapani under 44 number Jonia LSE. Proceeding stated that her name was also enrolled in the voter list of 1997 at village Rangapani, but she has been marked as D voter. Proceeding in her evidence in SIP as W1 by way of affidavit, what she has stated in her written statement. The proceeding second party was cross-examined and she exhibited some documents which were compared with the original and marked as annexure A to annexure I. It doesn't mark here. I have perused the case record along with the WSN evidence available in the case record. Proceeding submitted the following in documents. Exhibit A, 1966 voter list, B, 1970 voter list, C, 1997 voter list, D, land revenue receipt, E, 1993 voter list, F, Gapunsa certificate, G, voter identity card, H, voter identity card, Exhibit I, Gabura certificate. After going through the written statement, it appears that the proceeding has not mentioned her mother and brother's name. Proceeding also mentioned in the written statement that her father name enrolled in the voter list of 1966 and 1997. Proceeding has not mentioned why her father name not listed in the voter list of 1997. 1970. Though she was claimed her citizenship by birth, but she has not mentioned when she was born. She remained completely silent as regard her grandmother and the children of her projected grandfather. Alimuddin, when one's citizenship is being questioned by the state on has to disclose to all material facts which are within her special knowledge to prima facie establish her citizenship of India and required to be proved by everything present and reliable evidence. In the evidence on affidavit proceeding, first time mentioned her mother's name as Asirun Nessa, alias Asia Khatun, and also mentioned about 1997 voter list. The evidence proceeding, he also mentioned that her father possessed a plot of land at village Rangapani. In the cross-examination proceeding deposed that her father expired 4 years back and mother is still alive and she has 4 brothers. In order to substantiate her claim of her parents' existence, have produced voter list of 1966 annexure Exhibit A and voter list of 1970 Exhibit B. On perusal of both the voter list of 1966 and 70 appears in the name of the projected parents along with other members of her family, though proceeding has mentioned about her projected parents, but she failed to disclose the other entries appeared in the voter list of 1966 and 70. Another important aspect which needs to be noted that proceeding neither brought any persons appeared in the voter list of 1966 or 1970, nor any witness before the tribunal to prove the contents of the voter list of 1966 and 70 to establish the linkage of her parents. But his brother appeared, my brother also deposed in the court, DW2.
See, what is the law laid down by their lordships in the Sarvaranda Sonwal 1?
And Exhibit D, land revenue receipts. All the proceedings have submitted a revenue receipts of 1952. It does not prove that whether the proceeding's father or his family was residing over the said plot of land during that period as well as presently. Proceeding also not submitted any other related document regarding the land which was mentioned in the evidence. Actually, land on which we have submitted by the petitioner, my lord. There is the land on which they are residing till that there, and village Rangavan is the bond place. She has bond there, my lord. And she has also been married in the same village and residing
See,
there.
what was the requirement as per the decision of the Honorable Appeals Court in the case of Sarvananda Sonwal 1?
To prove, my lord, that document, yes.
What is the requirement? A proceeding should give what? Full details. of
Full
the family
details of
member,
the, my lord,
Right.
family and what that is.
Right.
Yes.
Now, you have seen in her written statement as well as in her evidence. For the first time, she mentioned the name of her projected mother. in
But
her
in
written-
cross, my lord, she has mentioned her mother's name, also
Mr.
brother's name.
Rosit, you are fully aware, right? And secondly, you never
Actually,
mentioned
what-
about the name of your
Actually,
brothers.
your lordship is right, my lord, but what happened, my lord, in this case, I have seen also, my lord, your lordship is right. Everything was ready, but only, my lord, is the fault from my side, my lord, as I could not
So,
write everything in that clearly.
See, Mr. Rashid.
In WS, this should be contained, my lord, name of father, name of mother,
Definitely the things
grandfather,
are this,
and brothers.
a council will write what? Only when the things are before him. When the proceeding fails to, because proceeding picks up those documents later
And
from different.
when the learned member will ask about her family members, my lord, she stated everything. That means I know my name, my father's name, my brother's name. But the
Now, where did
advocate is
where
the
did
writing.
the
I am
proceeding
informed, my
stated?
lord.
Kindly tell us, where did the proceeding stated before the tribunal about his brothers or sister? Either in the written statement or in a written
No,
evidence.
only cross, my lord, cross she has stated, yes.
How
Your
did it
lordship
should
is
be
right.
accepted? And that is why the law laid down by the apex court very
Actually,
clearly.
it is the fault of the advocate, my lord, like me, my lord. And if I don't make any question to her, my lord, or the
See,
petitioner, how he will, my lord, say, these are required, not required?
when the judgment of the Honorable Apex Court of Sarvanda Sonwal was there,
That was probably 2005,
2005. When did the written statement was filed?
long after, my lord,
July 2018.
long after. About 30 years.
Tell us whether this is a matter to be for consideration for admission.
A record before lordship. So,
Record is before us. We are perusing on records. From the
Right.
records only we are saying.
there is a record is lordship. And
Tell us,
DW2 Miller, see, Shadullah, he is one of the brother Miller.
where is that name of the Sadullah in the written statement or in evidence? Written evidence. First of all, we cannot accept anything, even if there is
Who is,
written
who
evidence.
is coming from
If it
outside,
is not
yes.
mentioned in the written statement.
I'm agree Miller to that.
So
And it is a burden on.
Only not in cross-examination, I have mentioned that Sadullah is one of my brother.
But is it to be accepted? So that the
But
tribunal. needs
I
to
have not
accept.
mentioned, nothing is mentioned about my family and other members, my brothers, sisters.
And you see, what the tribunal found is that if your father have expired 4 years back, mother is still alive after 1997.
Mother is alive, so she was able to come to the court, my lord.
And you have not
Easily.
reduced neither any voter list after 1997, or you have reduced evidence of your mother.
That is not my fault.
Tell us.
And
Okay, yes, Mr. Gunjan Sharma, tell us what to do.
Lordship,
yes, sir, hopefully, right.
Lordship, case may be dismissed in limine also on the ground of delay and laches, Lordship.
Really?
Yes, Lordship. Opinion was passed in the year 2018, and what ground they have taken, Lordship will see in the writ petition para 11, that the impugn order was passed on 23/10/2018 by member Foreigners Tribunal number 1 Borpeta. They received the copy of the order on 11/1/2019. The petitioner is a poor woman without any source of income. She was collecting legal expenses, cost of the case. In the meantime, some period passed for lockdown. Again, she collected legal expenses of the case, and she came to Guwahati on 24/1/2025. Contact with her advocate. The case is prepared and filed on 27/1/2025. Hence, there is some delay. Your Lordship may be pleased to condone the delay, admit the petition, and consider on merits. Otherwise, the petitioner will suffer irreparable loss and injury and financial hardship. Lordship, if she is a poor lady, Lordship, why she did not approach before the state legal service authority, Lordship, for his legal aid, Lordship. And Lordship, regarding a delay and laches, Lordship, Honorable Supreme Court has decided in so many cases. One recent decision, Lordship, civil appeal numbers 5027 of 2024. Lordship, just I am reading the relevant paragraph, Lordship. Para 11, I am reading, Lordship. For filing of a writ petition, there is no doubt that no fixed period of limitation is prescribed. However, when the extraordinary jurisdiction of the writ court is invoked, it has to be seen as to whether within a reasonable time same has been invoked, and even submitting of memorials would not receive the date cause of action or resurrect the cause of action which has had a natural death. In such circumstances, on the ground of delay and laches alone, the appeal ought to be dismissed, or the applicant ought to be non-suited. If it is found that the writ petitioner is guilty of delay and laches, the High Court ought to dismiss the petition on that sole ground itself, inasmuch as the writ courts are not to indulge in permitting such indolent litigant to take advantage of his own wrong. It is true that there cannot be any waiver of fundamental right, but while exercising discretionary jurisdiction under Article 226, the High Court will have to necessarily take into consideration the delay and laches on the part of the applicant in approaching a writ court. This court, in the case of Tridip Kumar Dingal and others versus State of West Bengal and others, 2009, 1 SCC 768, has held to the following effect. Para 56, we are unable to hold the contention. It is no doubt that there can be no waiver of fundamental right, but while exercising discretionary jurisdiction under Article 32, 226, 227, or 136 of the Constitution, this court takes into account certain factors, and one of such considerations is delay and laches on the part of the applicant in approaching a writ court. It is well settled that power to issue a writ is discretionary. One of the grounds for refusing reliefs under Article 32 or 226 of the Constitution is that the petitioner is guilty of delay and laches. If the petitioner wants to invoke jurisdiction of a writ court, he should come to the court at the earliest reasonably possible opportunity. Inordinate delay in making the motion for a writ will indeed be a good ground for refusing to exercise such discretionary jurisdiction. The underlying object of this principle is not to encourage agitation of stale claims and exhume matters which have already been disposed of or settled, or where rights of third parties have accrued in the meantime. Hyde State of MP versus Bhailal Bhai, AR 1964, SC 1006. Some Supreme Court citation has been given here, Lordship. These principles applies even in case of an infringement of fundamental right. Fundamental right, Lordship. Then, Lordship, next para, there is no upper limit and there is no lower limit as to when a person can approach the court. The question is one of the discretion and has to be decided on the basis of the facts before the court, depending on varying from case to case. It will depend upon what the breach of fundamental right and the remedy claimed are, and when and how he delay arose. So, Lordship, again in para 12 is also important, Lordship. It is apposite to take a note of the dicta laid down by this court in Karnataka Power Corporation Limited and Andhra versus K. Thangappan and others 2006 for SCC 322, whereunder it has been held that the High Court may refuse to exercise extraordinary jurisdiction if there is negligence or omissions on the part of the applicant to assert his right. It has been further held thereunder. Delay and laches is one of the factors which is to be borne in mind by the High Court when they exercise their discretionary powers under Article 226 of the Constitution. In an appropriate case, the High Court may refuse to invoke its extraordinary powers if there is such negligence or omission on the part of the applicant to assert his right as to taken into conjunction with the lapse of time and other circumstances causes prejudice to the opposite party. Even where fundamental right is involved, the matter is still within the discretion of the court as pointed out in Durga Prasad versus Chief Controller of Imports and Exports, 1969, 1 SCC 185. Oh, so Lordship, again, Lordship, next para, Lordship, what was stated in this regard by Sir Barnes Peacock in Lindsay Petroleum Company versus Prosper Armstrong Hart, 1874, Privy Council 5, Privy Council 221, 22 WR 492. So, Lordship, here also, Lordship, now the doctrine of laches in courts of inquiry is not an arbitrary or technical doctrine, where it would be practically unjust to give a remedy either because the party has by his conduct done that which might fairly be regarded as equivalent to waiver of it, or whereby his conduct or neglect he has, though perhaps not waiving that remedy, yet put to other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In either of these cases, lapse of time and delay are most material. But in every case, if an argument against relief, which otherwise would be just is founded upon mere delay, and that delay, of course, not amounting to a bar by any statute or limitation, the validity of that defense must be tried upon the principle of substantially equitable. Two circumstances always important in such cases, the length of delay and nature of the acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking the one course or other, so far as relates the remedy. So, Lordship, this is detailed judgment, Lordship, regarding delay and laches, Lordship. again in,
Do you have the party's name here?
yes, Lordship. Mrinmoy Meiti, civil appeal 5027 of 2024.
Civil appeal?
Civil appeal numbers 5027 of 2024. Special petition civil number 30152 of 2000.
Mrinmoy, M-R-I-N-M-O-Y.
Yes, Lordship. Maity.
Mrinmoy
Meiti, Maity.
versus
Sanda Kole, CHHANDA, KOLEY, and others.
decided on
Decided on Lordship. Decided on April 2024, 18 April 2024. Para 13 is also important, Lordship. This is also said, thus the doctrine of delay and laches should not be lightly brushed aside, Lordship. Here, in this case, Lordship, inordinate delay occurred, Lordship, in this case. So, Lordship, if you ignore the delay also, Lordship, then also petitioner failed to establish his link with his projected father, Lordship, in this case. And page 43, Lordship, read petition. What Gavura certifies, Lordship, only certified that the person concerned is a D voter, not apart from that, Lordship. Maybe, like, I have supplied, Lordship,
overlooking.
if required, Lordship.
Yes. Anyone want to submit?
And Lordship, if Gavura's evidence goes, Lordship, then nothing will remain, Lordship.
So Gambura has said that he relied on the voter list of 1966,
Yes, Lordship.
1970, and
1997.
97. Now, he did not state
Yes, Lordship.
the proceeding is the daughter
Yes, Lordship.
of her projected father.
Yes,
It's basically on his knowledge,
yes,
that of Tonu Mia.
yes,
There is nothing to prove, any document to prove before the tribunal or directly in which her projected father,
yes, Lordship.
because the certificate issued by the Gambura
Yes,
relates to wife of Kurban Ali.
yes, Lordship.
It has nothing to do with that daughter of Tonu Mia.
Yes, Lordship.
If you see at the exhibit at page
43, Lordship.
43, it's saying the wife of Kurban Ali.
And
And here also no mention that that her husband has expired.
yes,
So even this certificate, let us assume it's to be given by the concerned Gambura. It doesn't indicate anything that says the daughter
Lordship.
of Pranumi.
But my lord, page 28, she has deposed in the court that her father's name is Sonumia.
That is his personal knowledge.
Yes, Lordship.
That is not any from any document.
She has stated.
He might have said, but what is the basis? When we inquired, he said, I have given it from the voter list of 1966,
Yes,
70
Lord.
and 1997.
And Lordship, page 29, Lordship, মই দ্বিতীয় পক্ষক 6-7 বছৰৰ পৰা জানো
Hmm.
আৰু দ্বিতীয় পক্ষৰ পিতাক মই 10 বছৰৰ পৰা চিনি পাওঁ so
He did not produce any register, right? So, Mr. Rashid,
Here, my Gavro also deposed and brother deposed, but brother name
where
not,
is his brother?
not
Brother
mentioned in the
cannot come
Gavro.
from the sky straight away. Right? Neither you have named your brother in your evidence, in your written statement, nor your written evidence.
And Milan, regarding delay, my friend, another friend has stated Milan Subuko decisions. But this is Milan, she is an woman, Milan, aged about 60 years, and Milan, my submission
You
that
consider that as.
that is a Milan, civil appeal was there, and this is Milan regarding fundamental rights.
Okay, she's
So,
a 60 years
that-
old lady.
I was trying to file Milan, but I was never due to Milan some other problems, your lordship. And lockdown was there and financial problem was there.
Look. Heard Mr. A. Rashid. Counsel for the. No representation on behalf of the respondent number 1 in your video. Also heard Mr. Z. Sharma, Senate Council, Government Political and Numerical, and ANC. Senate Council, NRC Assam. For the respondent numbers 2, 4, and 6. Mr. P. Sharma, additional senior government Assam, for the respondent number 3. And Mr. M. Kolita. On behalf of Mr. A. Standing Council, MSP Borua, PRUH. Standing Council ACI. For the respondent number 5. Right. Agree by your opinion. The 23/10/2018. By the impugn opinion dated 23/10/2018. Passed by Learned Foreigners Tribunal number 1st, Borpeta. In Foreigners Tribunal case number 03/2017. in a reference being forwarded by the Superintendent of Police Border Borpeta. But case number 7637 within bracket capital A oblique 1998. After hearing the parties and considering the evidence adduced by appoint the petitioner to be a foreigner under the foreigner of post 2503/1971. Agree by the said order, said opinion, the 23/10/2018. The petitioner filed this writ petition on 28/01/2025. After about 6 years, 2 months, 3 months, make it 2 months. The petitioner submitted that though she obtained a certified copy of the said of the impugn opinion dated 23/10/2018 on 11/01/2019. And she being a poor woman without any source of income, only after collecting the legal expenses, she could come to Guwahati on 24/01/2025, contact her advocate, and file this rate petition on 27/01/2025. The court by order it 14/02/2025. While issuing notice, call for the records of said FT case number 03/2017 from the concerned foreigner tribe. We have perused the same. It is seen from the records of the case that during the house-to-house enumeration in the year during January 1997 to April 1997. The local verification officer within bracket LVO submitted its report that the proceeding, the petitioner hearing could not furnish relevant documents with regard to recording of her name in the voter list of 1997. The concerned electoral registration officer of 44 Junior Assembly constituency, after due verification, on 19/01/1998, submitted its report before the Superintendent of Police, put in bracket border Borpeta. Nineteen zero one 1992, 14 bracket you write 14/03/19. White number JN/107/62/2039. Recommending the case of the petitioner for the determination as to whether she is a citizen of India or not under the Foreigners Act 1946. Pursuant to the same, the Superintendent of Police Border Borpeta dated 21/08/20, so 21/08/1998, file number 7637 within bracket capital A. Forwarded the case to the Foreigners Tribunal. Forwarded the case to the chairman. Illegal migrants within bracket determination. That was tribunal. Borpeta. To opine as to whether the petitioner is a foreigner or not. Under the Foreigners Act 1940. After the decision of the Honorable Supreme Court in the case of Sarvanda Sonwal versus Ravinia Nathas, reported it such and such. And since the case of the petitioner forwarded by the Surrender Police Border Borpeta was pending for consideration. As noted. Was placed before the Foreigners Tribunal. One, at Borpeta. For necessary consideration under the Foreigners Tribunal's Order 1964. The said tribunal reported to that, which was accordingly registered as Foreigners Tribunal's 03/2017. The concerned tribunal on 05/01/2017 issued notice to the petitioner. Fixing the matter on 01/02/2017. Enabling her to issuing so called to file an affidavit. Plus written statement. To prove her citizenship. And for necessary clarification to show that she has not entered into territory of India on or after 25/03/1971. Fixing matter on 01/02/2017. According. The petitioner on receipt of notice appeared before the tribunal on 01/02/2017. And after taking time, filed her written statement on 06/05/2017. The petitioner on 17/08/2017 submitted her written evidence before the tribunal in said FP case number 03/2017 and was cross-examined on 12/06/2018. The petitioner also adduced evidence of one Sadullah Mia as DW2, stating that he is her brother. And also one Panjit Patwari, government counselor of village Gojia, as DW3 on 03/08/2018, who issued a certificate on 02/07/2018 in favor of the petitioner. Exhibit I. To prove her citizenship, the petitioner exhibited a voter list Mr. Rashid, please come to page number 37. The
Annexure 6.
annexes that was exhibited before the tribunal, right?
Right.
What is missing here? What is missing here? As per the evidence act. To consider the certified copy. What
My
is missing?
grandfather's name is not there.
Hmm?
There is Alimuddin.
What is missing here to consider as a voter certified copy?
Probably date of application is there, date of receipt of there in us, date of ready, and
Something is
date
missing. What is missing? The round seal of the office.
oh, rounds.
Law is very clear.
But Milord, one thing,
Anyway,
asking.
We'll do-
Round seal is there, Milord. Has the lordship got in the first Milord, 29/8/14, above that Milord, there is one round seal.
We are having the original copy before us, which you have exhibited before the tribunal.
No, that is only lordship. And that is Milord,
Anyway,
নির্বাচন উপায়ুক্ত কার্যালয় নির্বাচন লেখা। Has the lordship got that?
it is not here before the tribunal. We have, anyway, it was comparative originally, it doesn't have the round seal, it's a photostat copy.
No, Milord, probably here, Milord, there is small seal, Milord.
So for the time being, will not contact. The case of the petitioner before the tribunal as per our written statement filed on 06/05/2017 is that the name of her father, Tonu Mia, son of Ali Mutin, permanent resident of village Rongapani, police station, Borpeta, and his name figured in the voter list of 1966 at the village Rongapani, police station, Borpeta, under 51 number Jania Legislative Assembly constituency, at part number 42, house number 16, serial number 46. She also stated that name of her father, Tanumia, figured in the voter list of 1997 at village Rangapani Police Station, Borpeta district, Borpeta, under 44 number Jonia LSC, white part number 107, house number 6, serial number 21. She stated that she is married to one Kurfan Ali, son of Abdul Ali, of village Rangapani Police Station, district Borpeta. And since her marriage, she has been residing at village Rangapani Police Station, Borpeta, the house of her husband. The father stated that name of her father, that her name figured in the voter list of 1993 at village Rangapani Police Station, Borpeta, under 44 number Jonia LSC, part number 107, house number 6. That's serial number 38. Though her name figured in the voter list of 1997, she was marked as Putin Kolundi voter. They stated that she is a bona fide citizen of India by birth and no inquiry team ask her any question arising out of her nationality. As such, she prayed before the tribunal to drop the proceeding against her. In support, no, to prove her contention, the petitioner exhibited a certified copy of voter list of 1966 pertaining to 51 number Zonia LSC, village Rangapani police station, before that is right, village Rangapani, part number 42, house number 16, police station Borpeta, wherein name of her father Tanu Mia, son of Ali Mutin, figured at serial number 46. The petitioner also adduced as exhibition at Exhibit A. Also exhibited English translated Assamese version of certified electoral roll of voter list of 1970 of 51 Junior LAC. Part number 49, house number 60, village Rangapani. Wherein name of one Tonumia, son of Alimuddin, figured at serial number 61. Further, the petitioner exhibited the voter list of 1997, certified copy of voter list of 1977 of 44 Zonia LAC. Part number 107. House number 6. Serial number 21. Wherein the name of Tonu Mia, son of Alimuddin, reflected at serial number 21 as Exhibit C. The petitioner before the tribunal exhibited a land revenue receipt dated 27/07/1952 for land for external land of village Rangapani for the Assamese year 1389/1390/1391. Issued in the name of four persons, including one Tonumia, whom the petitioner projected as her father. Petitioner also relied on voter list of 1993 pertaining to 44 Jonia LSC, village Rangapani, part number 107, wherein her name figured serial number 20, house number 6, singly as wife of Gurpat. In addition to those, the petitioner exhibited a certificate issued by the secretary of 77 number Gazia Medhir Tari Gaon Panchayat, issued on 07/07/2015, indicating her as the daughter of Tonumia of village Rangapani as Exhibit F. Her. The petitioner did not prove the said certificate. There is 07/07/2015 issued by the secretary of 77 number Gazia Medhir Tari Gaon Panchayat, by adducing evidence of the issuing authority by the Secretary of State Guardian of the Conference or the President of the State Conference. Petitioner also adduced a photostat copy of a voter list of 44 Jonia LAC of the year 1997, which has not been proved as exhibit annexure I, which has not been proved by adducing the certified copy of it, wherein she was shown to be a doubtful voter. The petitioner also exhibited the certificate dated 02/07/2018 issued by the government Kaungura village admin of village Gojia. No, don't. After filing her written statement on 17/05/08/2018, written evidence, written evidence on 17/08/2017. She also filed written evidence of Sahadul Mia on 05/07/2018. DW2 of his brother, of her brother. Though in her written statement, the petitioner did not name her mother, her brothers, or anyone of her siblings. In her written evidence, for the first time, she stated name of her mother as Asiron Nessa, alias Asia Khatun. Whose name figured in the voter list of 1966 and 1970 at village Rangapani. At house number 16, at serial number 46. Sorry, at serial number 48 and '63 respectively. It is seen from the records of the case that the petitioner, even in her written evidence filed on 17/08/2017, did not mention about her siblings, brothers and sisters, nor stated about the certificate issued by the common village headman of Gojia village, that was exhibited before the tribunal as Exhibit I. In our cross-examination, but it depends. No, the mentioned by the state. On being inquired by the court on 12/06/2018, the proceeding stated before the tribunal that name of her husband is Kurpan Ali. She resides at village Rangapani and was also born at village Rangapani. Father's name is late Tonu Mia, who expired about 4 years back. And her mother, Asirun Nessa, is alive. She has 4 brothers and accordingly named them as Abbas Ali, Sadullah, Jalal, and Alal. The DW2 brother of the alleged brother of the proceeding. In his evidence reduced before the tribunal that name of his mother is Asia Khatun, and in some place it is written as Asirun Nessa. They have a plot of land at village Rangapani, Moja Jonia district Corpeta, white pattern number 17/67. And revenue receipt was issued to his father by the authority concerned on 22/07/1952 as Exhibit D. His name figured in the voter list of 1997. Under 44 number Jania LS, part number 107. And that Alam Mia Jalaluddin and Alaluddin are his brothers. And the prosody Bilaton Nessa, the don't write prosody, Bilaton Nessa, Rajia Khatun, Anwara Khatun, Milon Nessa, Abeda Khatun are his sisters. His father Tonumia expired 4 years back at village Rangapani, and mother is still alive. And that the prosody married to one Kurpan Ali, son of Abul Bali of village Rangapani. And thereafter, and after her marriage, she is permanently residing at village Rangapani. He also exhibited Exhibit G, electoral photo identity card issued in his name, and Exhibit H, an electoral photo identity card issued in the name of his mother. During his cross, the projected DW2 projected brother of the proceeding, Sadullah Mia stated that name of his father is Tonu Mia, who expired about 4 years back, and his mother is alive. And Bilaton Nisa is his own sister. Name of his mother in different documents has been recorded differently. And though he applied for correction of name of his mother before the election office, but he did not adduce any such document before the tribunal. Did not exhibit. And also did not exhibit any land document before the tribunal reflecting the name of his father. And that name of husband of a petitioner / proceedor is late Kurpan Ali. The proceedor also adduced evidence of the DW3, the Gambura of Gazia village, Panjit Paturi. Who in his evidence before the tribunal deposed that he is the village headman of the villages Koretol, Gajia, Ograndha, Rongapani, and Rongapani. Since he knew the proceeding, don't write, he knew the proceeding. Name of her father is Tonumia, who expired about 4 years back, comma, or you can write me. The name of her mother is Asia Khatun. The proceeding was born at village Rongapani and also married at village Rongapani. Name of her husband is Kurpanali, who expired about 2-3 months back. And exhibit I is his certificate issued in the name of the prosecutor. On being inquired by the tribunal, the said proceeding, it said DW3, village headman of village headman, stated that since 14 December 2015, he is the village headman. And there are about 14,000 people resides in those villages. Since 2018, February, he is maintaining a register. He knew the proceeding since last 6-7 years and had known her father since last 10 years. He also stated that considering the voter list of 1966, 1970, and 1997, he had issued the certificate. As noted above, the petitioner in her written statement did not state in full details pertaining to name of his mother and other siblings. In her evidence on being inquired by the tribunal, the proceeding only stated that she has 4 brothers as Abbas Ali, Sadullah, Jalal, and Alal. Whereas her projected brother, Sadullah, deposed before the tribunal that his brothers are Alam Mia, Jalaluddin, and Alaluddin. And 5 sisters, including the proceeding. The proceeding in her evidence did not state of having any such brother named as Alam Mia and named one Abbas Ali, which was not mentioned by her projected father. The proceeding before the tribunal also did not name of her sisters, nor stated about him, though her projected brother Sadullah named all the 5 sisters born to his father Tonu Mia and mother Asia Khatun. Asia Khatun, including the proceeding. The proceeding did not state about of issuing any such certificate by the village headman of village Gojia in her written statement as well as her in written evidence, though she adduced the evidence of the village Gaubra of Gojia village, who issued the certificate in favor of one Pilaton Nesa certificate issued on 0207-2018, showing her to be the daughter of late Tonumia of village Rongapani, Moja Jonia, Post Office, Johor Palm District, Borpeta, stating that her name has been shown as the voter and was married to Urban Ali, son of one Abdul Ali of village Rongapani. With the state emblem on it. The petitioner in her evidence categorically stated that she is the wife of Urban Ali and not of Urban Ali. Considering the decision of the court in advance of this court in the case of the certificate of the concerned village headman issued on 0207-2018 cannot be considered as a piece of evidence. In addition to that, the said certificate was issued by the said village headman, the W3, only on the basis of the voter list of 1966, 1978, and 1997, but not on the basis of any contemporaneous record. The evidence of the proceeding slash petition and are projected by the DW2 Satilomia as noted above. Has lots of discrepancy. Have you stated that in the case of Samantha Tunal, one we have already stated, I think. So we have stated. Considering such materials in the case record and on the basis of which the opinion, impugn opinion, dated 23/10/2018, issued by the learned member of Fairness Tribunal number 1, Corpeta, in Act case number 03 of 2017, cannot be considered to be an illegal one as the proceeding failed to establish before the said tribunal about a link with his father, with her father, who was in Indian soil continuously prior to 25/03/1971 and thereafter. From the records, it is seen that petitioner failed to show any documents or materials before the tribunal to show a link with her protected father, Tonumia. For the reasons above, we did not find any illegality with the order dated impugn opinion dated such and such passed by the learned justice. This liquidity is dismissed. The registry shall return the records of Fairness Tribunal case number 03/2017 and a copy of this order. Photo. Must.
Will be your lordship, kindly the matter will be adjourned for the day, lordship.
Can you tell us, ma'am, when did the petitioner appear before the Superintendent of Police Board of Dhubri? After the impugn order, after the order dated
7/3/2021, lordship, when she appeared, I have no knowledge, lordship.
So that's what is important for us. To consider your prayer for adjournment. On the pair of the petition, place this matter on 3rd of April.
Where's lordship?
Verma. Single. No representation on behalf of the petitioner and form. The name of the council. It is seen that there is no inherent protection to the petitioner. Based on. Heard. The model. The model. That's it. Even in last occasion, I on 14/03/2022, the petitioner remained unrepresented. Based on. The term of same council.
May I please, Lordship?
Why this matter has come for hearing?
My lord, in the long list, part two list, there is, it is entered into that list, and subsequently, I do not know why that list.
Heard. Mr. K. U. Ahmed, counsel appearing for the petitioner. No representation on behalf of the restaurant number one Indian Revenue. Heard Mr. H. Puli. Granted counsel on behalf of Mr. A. Ali standing counsel ECI for the restaurant. Mr. Pathak, you are appearing?
Yes, sir.
H. Pathak, right?
And Pathak.
N. Pathak. Standing counsel, home and political, numerical and you are also representing NRC?
No, sir.
Just home and again, political department, the state for the restaurant number 3, 5, 3 and 5. Mr. G. Sharma, standing counsel NRC Assam for the restaurant number 4. And Mr. P. Sharma, additional, senior government, additional senior government. On perusal of the orders passed earlier by orders passed by the court earlier in this writ petition. We have seen that this writ petition has not yet been admitted. And you notice the respondents of the issue. Registry has already received the relevant record that was called for from the concerned foreign staff. Place this matter for admission on 5th.
My lord, it may be on 20.
Saturday, it's a working day. When do you want?
Well-
4th? Okay, on 4th,
My lord, 21st,
after view vacation.
my lord.
When did you appear before the Superintendent of Police Court of Supreme?
Immediately after passing that,
When, give us the date. You get the date and let us know. We'll fix it on 5th.
Maybe Lord. Okay, yeah, Your Lordship, I prayed for adjournment in this case like, for today, Lordship. Maybe taken up after due vacation, Lordship. Also, I am also not confirmed as to whether this matter is admitted or not, Lordship. The order is not yet with my knowledge, Lordship.
Second
22nd.
for hearing. Hello, is it that the petitioner shall apprise the court as to when she appeared before the Superintendent of Police order come person to be ordered dated 19/07/20. Yes, Radha Rita.
May I please? Before we let's take your lordships to what the minutes, may I just explain to your lordship briefly what the matter is about? Because these two writ appeals by NRL Miller arise out of disciplinary proceedings initiated against two of the respondents, 283 and 284 writ appeal. They were in charge of the Millard's warehouse and the materials management part, the logistics of the organization. The specific issue in the present matter is that related to auction of goods. There, a fire had broken out in the godown of NRL sometime in 2013-14. And those goods which were marked as fire, damage, scrap, etc., they were set out for scrap auction. So there were two lots, lot 1 and lot 2. The same person had won the bid for lot 1 and the lot 2 as well, the same bidder. But because he could not give the earnest money for the lot 1, so that was cancelled, so he picked up lot 2. Now, in the process of when the lot 2 was given, and that is one of the charges against them, it is that they gave away good material along with bad. Meaning
It was meant for auction or not?
that was not meant for auction. Material which was not meant for auction, that is the allegation against it. Now, Millard, and if I may say so, Millard, they said so because there are the appellant in 283, these are confessions and admissions on record which are disregarded by the learned single judgment. The confession and admission is not once but twice or thrice. The whole
Do you have anything that was to show before the disciplinary authority that the materials which were kept in the warehouse not meant for auction?
Yes, but I am today going on a confession, their own. It is, they themselves say it isn't. They gave a confession by way of an explanation. They say that there was the first lot which was auctioned, that the bidder had quoted was apparently they said the explanation they gave had wrongly been informed, and he had quoted too high a price. He had suffered a loss. So, and because he forfeited the 1,75,000 rupees earnest money, they said that we will compensate you in the lot 2 by giving you material which will compensate you for this. That is the explanation they gave. So it is an admission, confession, which is by an explanation. And Millards, once this was discovered, because the discovery also happened that on the day that the materials were taken out, Millards, for taken out from the warehouse, and that too on a non-working day, because according to the rules of the organized corporation, non-working day, e-auction goods cannot be traveled. And Millards, they were taken out on that day, and then it was by outside external intelligence that someone from the press had complained to the local police, and the police actually landed. We were as an organization not aware of it. So they came, there were 3 trucks which were Millards there. Then they were taken Millards to the police station, and then Millards an inventory was carried out, and at the bottom of the 3rd truck Millards, they discovered copper cables, which was worth around 16.5 lakhs copper cable. And which was the fact. So then there were three sets of, there were two inquiries actually. One was a vigilance inquiry and one was a departmental inquiry prior to the disciplinary proceeding. In both the inquiries, the appellant, the respondent in the first appeal, gives the explanation, and not once, over 2-3 occasions, spread over various dates, that because we had to compensate the bidder for the loss suffered in the first, alleged loss suffered by him in the first bid, because he had quoted too highly, because we had given some wrong information, they never disclosed what wrong information was given, is why we gave it to him, why we compensated him by giving this. So it is an admitted fact. It is not that there is any dispute that they had given it away. And the respondent in appellant number to it, because the appellant respondent in the first appeal was the one who was the assistant materials manager, and the respondent in the second appeal, who is Mrs. Goswami's client, is that he says he was the superior officer, who also corroborates this by saying that Diganta Haloi, the appellant, the respondent in the first, had asked me about it, but I had said no. So her client says that, so this is corroboration from all fronts. Now, the law on this aspect is very clear. And then what happens is this admission happens first time on the 2nd of April, then on the 3rd of April, then after inspection is carried out on the 10th of April. This is also corroborated by physical verification of the goods. Then it is only when the disciplinary inquiries begins that on the 12th of July, after 3.5-4 months, that they retract. And it is a mechanical retraction saying that it is under coercion. Now, the entire proceedings has proceeded on the basis today, as far as we are concerned. And there is another aspect to it, because the learned single judge has wrongly relied upon a set of rules. He has said, he has applied the rules relating to premature retirement, which is not a penalty, to compulsory retirement. Now, compulsory retirement under the NRL rules is a penalty. He has said the procedure was not followed by wrongly applying those rules, and it is not the case that rules are not followed. He has applied the wrong set of rules were applied to compulsory retirement. So that is one grievance, because that kind of finding also hurts us, and that's very important. And the third is, there was some DVDs which were taken of the whole exercise, of the tables and all. The learned single judge proceeded on the basis of 65 capital A and B of the Evidence Act, saying that affidavits, etc. are not fine. And this is a law laid down by the Lordships and Supreme Court, that strict rules of evidence do not apply as long as there is some evidence that is enough for us to proceed. So today, and the entire confession admission, which is corroborated because that is relied upon in the inquiry committee, in the inquiry report, is all disregarded in just 2 sentences, that it was restricted, that it was made under coercion. Now, the law in this regard is very clear, that when there is an admission, coupled with a corroboration, and it's from corroboration facts and admission from surrounding circumstances, then that has to be taken and accepted in its entirety. And in any case, if there is a retraction, then as far as the coercion part is concerned, as far as the undue influence part is concerned, that has to be proved, that part has to be proved by them, and it is a simple mechanical reliance saying that I was forced to sign by documents by so-and-so, etc., by superior officer, will not suffice. So, it is in this context, therefore, because our main thrust of my case, and I may just share it with the Lordship, is admission, confession, which is on the basis of an admission, which is corroborated by surrounding circumstances, physical verification, admission where he himself says, by way of an explanation, that I gave it them to compensate. And then the other respondent in the other writ appeal also says that he asked me, but I didn't agree. So he sort of distances himself from it. So it shows, but the fact is that he was also aware that this is the reason for which that uncut cable was given to them. And whereas they were in charge of logistics, they were in charge of warehouse, etc. So obviously the penalty of, I think it was earlier, it was dismissal from service, and later on it was compulsory retirement. So which I think then they get some terminal benefits in that process. So that is the long and short of my case today.
I appear for the respondent writ petition, item number 9. So now left hand is I short writ petition application. I have there for adjournment. After we take it up after this, because we take some substantial hearing. My lord, respected bench. That's not the issue.
Yes, Mr. Hazarika, what do you have to say?
Give me given time, look up.
It will take about 2 hours, my lord.
No, I think. Kali answer.
Five to nine.
Problem.
Let me take it up after meeting, my lord, on a date convenient to my.
No, no, I have come. Your lordship
Because
is,
it was fixed earlier on the basis of the joint prayer.
yes, my lord.
But
Suggest,
problem will be he will not finish today and he's not there tomorrow. That will be a
Give
problem.
us a date when it will be possible for you. Give us a date like Tuesday so that you
Yes,
can
yes,
carry it on Thursday.
Actually, this month, my lord, because my lord, the week before vacation, can it be sometime in May, my lord, if it is all right to their lordships?
After Bihu, last week
No,
April,
no, no, no,
last
no,
week,
no, no, I'm not. You want last week,
last week April. 29th or
13th May will do.
13th
May.
May.
6th May, na? Both din ho jabo.
13th May, then, 13th May is, my lord, Tuesday. 1 week afterwards, my lord. I have some personal appearances also, my lord.
Lordship, the problem is my client is suspended since 2014. We have a judgment in our favor on the basis that.
I'm not seeking an adjournment.
I know. So
It's
little earlier is better. That is the
It
only
is
my
under
prayer.
stay. It is under stay.
No, Lordship, there's no stay because what happened the first time when it came up before the Honorable Chief Justice Court, and it said that, okay, we'll hear this prayer for interim stay on the next. Then it kept going on.
No, my lord, then
Finally,
thereafter, my lord, when it
consensus,
came up,
yes.
justice.
It went on, therefore we said it better to
Mr.
just.
Hazarika, let us have it immediately after vacation. Any date you will give us in the week commencing from 21st of April or from 28th of April,
Yes, yes.
if possible.
28th. Yes, my lord, I'll have to see.
Second
Then-
May lo lo ah.
Second-
Mate lage jodi.
Second May. Very well,
Did
second.
April.
It starts on a Tuesday. That's what we
Yes.
want. Either
Oh, yes,
22nd or on 29th or on 6th.
Second May.
29th then.
Up to you.
I'm,
Because
my
you
lord,
have to start
I'm ready today also. my
No,
lord.
we understand.
No, we are.
Okay.
But we will not give any further adjournment on next day.
Yeah, obliged.
So whoever it is, give us a date.
Second May, my lord. Huh?
Second May, not possible, it's a Friday.
Or Friday.
No, first May. First May is a Thursday.
So we'll start on Tuesday.
First May maybe May Day. May Day is a holiday.
May day we don't have a holiday.
6th May. 6th.
No, no, first May is all right. Take us.
6th May. Adjournment homework.
You start on a
6th
Tuesday.
May, my learned friend is in now. She also.
Start
Then 29th April.
First May, she has difficult. 6th.
Either 29th or 6th. Honguda.
6th May.
6th May.
Mr. Manta,
29th.
say,
So I'm comfortable.
because no further adjournment.
No further.
Because you are suffering, you are saying, right?
Yes.
And to some
Lordship,
extent,
we
it-
keep it on 29th.
No, no, in fact, Mr. Chaudhary has not, every time they came, I may say so because last 5 hearings because Mr. Chaudhary is not available. I'm ready, my lord. I don't need to do the hearing, but
Mr.
I-
Manta, note down. That is the reason we want that you should start on a Tuesday.
very well.
Lordship, I have it on 29th. Let's keep it on 29th and we'll see.
Mr. Hazarika,
29th.
No, no, 29 she has some difficulty. She has some difficulty, I'm going to keep it on the 6th of May.
6th more,
6th
more
May.
instructing council line.
No, no,
6th May, good, fine.
Fine.
Mr. Mohanta, note down whatever your submission is.
Yes.
6th of May.
Right.
Ms. Kusum,
Obliged, Lordship.
as agreed by the party, would the party. List on 6th of May. Okay. Thank you.
Obliged.
Great.
The matter may pass over for the day, Lordship. Lordship,
Item number?
May 5th and Friday, Lordship.
Much obliged.
Merely, my lord. I beg to mention item number 5, 6, and 7, my lord. The conducting council, Arbora, my lord, is indisposed today, my lord. Lords may pass out for that.
I think.
Obliged, my lord.
Meet page, your lordship. I beg to mention this bail application for listing on Friday,
22/5.
on 28/3. Obliged.
Yeah, please, the Lordship. I beg to mention for item number 13. On the last occasion, Lordship directed me to mention the matter before this honorable court that mandatory period is over. Today is 61 days.
Okay. We'll take it
Okay.
immediately.
God bless you.
You be here, we'll take it.
Okay.
You be here, we'll take up.
Okay, Lordship.
Yes, ma'am.
I beg to mention item number 16. CD not received.
My lord, here we have not received that case there, my lord. Here, IO has stayed for another date, my lord.
Just in.
My lord.
Full number 5. Tell us when.
My lord. Kokorazar, my lord.
This is Pokiragra.
Yes, madam. Okay, again.
My. Second. 25th, my lord. Service complete, my lord. here. No, no, CD no. Interim. They are also interim, my. Interim also, no?
25th.
My lord.
Prepare with conflict. Amendment of the ceremony. When did the petitioner appear? When did the petitioner? When did the petitioner appear before the IO?
Okay, listen, I also. Interim court for the listen. Okay, always the. No, no, no.
Yes.
Lordship, I beg to mention item 2. Kindly the matter may be passed over for the day.
Yeah, I'll make a billing person with that. 3-4 bullet.
From production is item number 1.
May please, Lordship. I may be allowed to withdraw this petition, Lordship.
You are Mr. Hannah.
Ms. Bidas on behalf of AM Ahmed.
RMF Vedas, counsel appearing for the petition. And Mr. MP Goswami and petition of the prosecutor. Petitioner namely Satyan filed this application on section 483 BNSS. Praying for the release on the Dolgom PS case number 233/2024. Arrested on 12/11/2024. On that section 20 within bracket P within bracket small roman capital C and NDPS 945. On instruction the petitioner, Ms. Das, be the पूरा नाम ही लिख दीजिए PANNY is not present is well praise for what developers. Look, it's
Master bless.
What's your good name, ma'am?
J. Begum Lordship.
For it. Mr. Applicant. Well, it's a application. Yes. 20/05. Praying for its faith. By her to put it, study a regulation, 25 of it. Under section 20 within the small b in the section of the public 29 NDPS in which he was arrested on 30/01/2005 and its custody is expired. Matter relates to recovery of 1.468 cases of ganja suspicious from the possession of the petition. Another Mr. Goswami and additional public prosecutor in on instructions submitted that with non-receipt of the official report, search it in the case could not be provided. Corresponding to GR number 66/2025. Considering his detention in custody since 31/01/2025, as on date, that petitioner and has already completed. Default. Criminal judicial magistrate from here. If indicated.
Master bless.
Please, your lordship.
Yes.
My lord, this is a criminal petition for crossing of a criminal proceeding, my lord. This is pending in the CGM court of Kamrup Metro, my lord. So, my lord, kindly come to page 17, my lord. The running page from which the case has been involved. An FIR has been lodged by the one person, namely Kolidas. So, lordship, kindly come page 17, my lord. May I read, my lord? Seventy-six, 75.
Yes, Suraj. Why should you interfere?
My lord.
What is the reason for interfere?
My lord, from the perusal of the FIR and the charge sheet and the material documents, 161 statement of the both the statement of the guard and other witnesses also. My lord, if your lordship kindly see, the section 375 has been attracted, police has been charged sheeted against me, my lord. Now lordship kindly see section 375, if your lordship for a moment.
Kindly read,
My lord.
kindly read.
Yes, my lord. So 375 rape, a man is said to be commit rape if he penetrate.
Upholding the order 25012024 passed by Learned Chief Judicial Magistrate Kokrajhar in this case number 4 M2 for maintenance of public 2023.
Lordship, the 25/124 order was set aside, Lordship. 25/124 passed by.
Just a minute, just a minute.
Lordship.
Don't write. Taking that. Order dated 13/02/20. Who has filed this?
Lordship, the husband. Lordship, maintenance. Lordship, maintenance of 18,000 was awarded. Thereafter, it was reduced to 10,000. Against that, criminal revision was filed, wherein that reduced order of reduction was set aside, and again 18,000 has been directed to. We agree by that, we are before your lordship.
One minute. Just simple. Everybody improved judgment in order to the 0 to 11 to 0 to 4. Passed by the annexation text in criminal division number 86/2024. Husnara Islam versus the middle of. And the order dated 13/02/2025. Passed by Learned Judicial Magistrate Pokrajar. In miss case number 32/2020. By which the petitioner has been directed to deposit the pending arrear maintenance amount along with the monthly maintenance amount by appearing in the court till clearance of the arrear amount and deduction of monthly maintenance from his bank account by the drawing and disbursing officer, and further directing the drawing and disbursing officer of the petitioner to deduct the monthly maintenance amount of rupees 18,000 from his account and to credit the said amount in the bank account of said Husnara Islam. The petitioner has prepared this criminal petition. Issue notice returnable by 30th of April. As Mr. MP Goswami and additional to be Sharma, additional prosecutor, some access notice on behalf of the no comment of this application. Petitioners are submitted extra copies by tomorrow. Petitioner shall take steps for service of notice on the opposite party number 2. By raise the property credit. Interim prayer of the petitioner shall be considered only after due service of notice of this criminal petition on the opposite party number list according.
Obliged.
May I please your wishes? My lord, in this case, I have challenged the entire proceeding under section 12 of the Domestic Violence Act. And the impugn order, my lord, PS last portion 69, PS 69 is my lord. Taking cognizance. Annexure 5. Relevant portion is 69, my lord. 25/7/2024, this is impugn order. Accordingly, issue notice to the respondents, namely Deepak Das, Nilima Das, Vinita Das, Gautam Das, and Ratan Das, to show cause as to why the release sought by the aggrieved should not be granted to her. Today, the exhibit also submitted her affidavit of disclosing assets and liabilities. But in this case, I will mention that Nilima Das is a dead person. Although notice issued on that date was a long back died. So without knowledge, Your Lordship, the fact of this case is that, my lord, the respondent is a outsider, stranger woman, no any relation with the petitioners. My lord, in this case, I am showing that Deepak Das shown the alleged to be the husband of the respondent. Now, Nilima Das alleged to be mother of the petitioner Deepak Das. Nilima Das is a dead person. Vinita Das is the sister of the Deepak Das. Page 69, my lord. Gautam Das is a brother, Ratan Das also their brother. They are living separately, no any connection with Deepak Das. Even that Nilima Das is a dead person, also mother, old as a woman. Now, Your Lordship will find in full order dated 25/7/24, Annexure 5, page 68. This Joyasri Mohanto is present along with her landed counsel. This agreed filed this petition under section 12, seeking relief, my lord. Page 68, relevant portion, below portion. Upon the consider, it is found that aggrieved applicant aggrieved aspirate for protection under section 18, residence under section 19, monetary reliefs under section 20, compensation section 22. But in this case, I will submit with Your Lordship that proceeding under section 12 for domestic violence offense under section 12 covers the relief portion only of since 18 to 22. These are the reliefs sought by the aggression, who is a stranger to the petitioners, my lord. She has no any connection, not a wife of the family, in the family of the petitioner Deepak Das. Now I am coming to the main point here, Your Lordship. Before this respondent, my lord, file Annexure 4, my lord, page 53. This is the complaint. Complaint under section 12, filed by this respondent Joyasri Mohanto, showing her age 29. Now, Your Lordship will find before this is a subsequent complaint filed against by the respondent against the petitioners. My lord, the original page number 25 may be perused, my lord. Plaintiff himself, plaintiff petitioner Deepak Das, my lord, petitioner number 4, page 25, he filed a petition, filed a title suit, my lord. This Annexure 1, page 25, my lord. Civil suit filed on 1/6/23. After 1.5 years, complaint is filed, my lord.
We have seen that.
She is not the wife, no relation with the petitioner. She is outside a woman. No any proof of marriage, my lord. So as per section,
Heard Mr. B. Hussain, learned counsel appearing for the petitioner. And let me investigate. The sole respondent on 05/01/2024. File an application under section 93. No. File an application 05 only like that. file an application under section 12 within bracket 1 of the Protection of Women from Domestic Violence Acts against the petitioners being aggrieved person praying for protection under section 18 comma residence order under section 19, monetary relief under section 20, and compensation under section 22. And further, a monthly maintenance of rupees 15,000 under section 23 of the said PWDB Act. The learned judicial magistrate first class Kamrup in bracket Metro Guwahati inside DB case number 230 in bracket particular 204 referred by the sole respondent. On perusal of the record and the domestic incident report and considering the domestic came to a conclusion that the petitioners have committed domestic violence against the aggrieved person sole respondent herein. And by order dated 25/07/2024 passed in say DB case number 230M2023. Issued notice to the petitioners directing them to take cause as to require relief sought for by the sole respondent, i.e. the aggrieved person, should not be granted to her. Agree with this, say, such and such. The petitioner has filed this criminal petition under section 528 of the BNSS. Criminal petition. Issue notice returnable by same day. Petitioner shall take step for some notification to show respond by tomorrow. By the correct so but it is to protect it.
But inter prayer made to stay
Interim
for
prayer of
the
the petitioner shall be considered after due service of notice and the sole respondent. List according.
inter prayer.
Not at this stage, it's a old case, it was September 2024 was the date.
May I please, Your Lordship? 528 application, Your Lordship. For quashing of a non-bailable warrant and for allowing to go on bail, Your Lordship. I had defaulted in my appearance, Your Lordship, before the court. Though I had taken bail before and I had appeared, and cognizance also have been taken in the matter. But due to some communication problem with my counsel, I couldn't appear on that day. So non-bailable warrant was issued, Your Lordship. I was subsequently arrested in another case also. That forwarding I have annexed in page 79, Your Lordship, annexed to B. I will appear, Your Lordship. Next date fixed in that case is on 4th of April, Your Lordship. I will appear, Your Lordship. Some protection may be given, Your Lordship.
What happened? What is the next date?
4/4, Your Lordship. NIC material.
You are Mr. DK Group.
Okay.
You are Mr.
R. Kumar.
R. Kumar. R. T. R. Councillor Karim. And Mr. P. Sharma, additional work. For this. The respond number 2. Number, right. Filed a complaint case under section 138 of the Negotiable Instrument Act, being share case number 19 of 2019. Therefore, the Court of London Judicial Magistrate in Marina against the petitioner pending before successful. On receipt of summons in said share case number 19 of 2019, the petitioner appeared before the Court of London Additional Chief Judicial Magistrate Morrigan. Around 25/05/2022, he was granted bail. Said case number 5. Since the petitioner failed to appear before the Court of London Additional Session, in said share case number 6, non-bailable warrant of arrest was issued against him for his appearance. It is submitted that in the meanwhile, the petitioner was arrested in connection with Azara Police Station case number 241/2024 under section 316 303 2 61 of the PNSS. As such, he could not appear before the Court of London Morrigan in said share case number such on the date fixed. Hence, this application under section 30. 528 of the PNSS. To cause the said order of the said non-bailable warrant of arrest issued against him in said share case number 19 of 2019. Report of Chief Judicial Body by Learned Additional Chief Judicial Magistrate Morigo. And to go on bail on his appearance. The copy of the order sits annexed by the petitioner in this petition. That prior to the issuance of the order of NBWA, by the concerned magistrate in said share case number 13. On two occasions, on 02/11/2023 and 26/12/2023, the said magistrate issued cost of rupees 1,000 each. As he remained absent. And they say it's here case number such and such. Without any tips. As such, the magistrate concerned on 20/06/2024. Sorry, on 06/02/2024 issued the order of NBWA against the petitioner for his appearance. In said CR case number 19/2019, which is pending for adjudication since (25/03/2019). That is on which the Learned Additional CJ Morigo took cognizance of the offense under section 138 of the NI against the petitioner. In said share case number 19 of 2019. Referred by the complainant, so as follows. Mr. Four Learned Counsel appearing for the petitioner submitted. That said order of NBWA is in force. And the next date of the case, said share case is before the Learned Additional CJ Morigo is fixed on 04/04/2025. It is also submitted by the petition on behalf of the petition that he shall appear before the said additional chief judicial magistrate Morigo in case number such and such. Priority. considering entire aspects of the matter and hearing the verdict. And in exercise of the powers conferred in Section 588 this criminal petition is disposed of, directing the petitioner, namely such and such, to appear before the initial judicial magistrate Mumbai in said CR case number 19 of 2019 on 04042025. Directing him to file appropriate application before the said magistrate on 04042025. Praying for the withdrawal of NBWA issued against him for his appearance in the said case. In the event of filing such petition by the petitioner for withdrawal of such and such, in the event of appearance of the petition and filing such application, the said magistrate shall consider and dispose of such application by petition on those terms and conditions securing the presence of the petitioner in the said CR case number on the date fixed. Till completion of the proceeding of the said such and such. Till then, such and such. The order of NBW issued against the petition in said CR case such and such shall not be executed. However, it is made clear that in the event of failure on the part of the petitioner to appear before the court of law, additional petitioner on such and on his failure to file appropriate application for withdrawal of such. The order of NBW issued again shall be carried in such whatever observation direction.
Obliged. May it please your lordship. Madam, on last Friday, the matter came up, your lordship. Procedure fixed it today. Today 64 days in custody, your lordship.
Mr. Goswami,
My lordship, here, my lord, investigation is going on, my lord, and regarding, my lord, this, my lord, regarding transaction in bank and also, my lord, analysis of CDR will be required because, my lord, so, my lord, there is illegal means to gain the, my lord, online transaction, my lord. So, my lord, by checking the mobile numbers and SIM cards of, my lord, another person's, my lord, they used to get the OTPs, and in this way, my lord, the transaction has been going on, my lord. So, my lord, now it is at the stage of, my lord, CDR analysis and also for, my lord, data analysis of the seized mobile phones, my lord, from the arrested accused person. And another, secondly, my lord, the another accused, my lord, who is whom, my lord, all the four petitioners are implicating that he is under him, my lord, they are working, my lord. He is absconding, my lord. Cannot be arrested.
That is not the issue.
That's it.
Malad, here, Malad, 64 days in custody today, Malad. They've got ample time for investigation. And moreover, Malad, some technical points are also there, Malad. The notice under section 47, 48, Malad, no grounds of arrest. Then, Malad, special act, Malad. Then, Malad, IT act, on Lordship knows, Malad. Then, Malad, the IPC cannot prevail, Malad. Special act is there, your Lordship. And moreover, the petitioner has two minor children, Malad, one 9 months and one 4 years, Malad. Well, they are local resident, Malad, 64 days in custody, Malad. Further custody, Malad, on any condition, Lordship may grant, Malad. Date of arrest is 28/1. From there, Malad, possibly, Malad, investigation might have been completed, Malad.
Today, madam, we have received a communication, madam. He is taking some time to give the update analysis report, and I was made some prayer, madam.
Malad, the 111 Lordship knows, Malad, it may not attract, Malad, because, Malad, Lordship knows, Malad, there should be two, Malad, Lordship knows, Malad, there. And, Malad, the remaining sections, Malad, it is 60 days, Malad.
Only 111 is 90 days.
111, Malad, the
Yes,
explanation, Malad. Two charge sheet, there should be at least one charge sheet, earlier, Malad, would have been submitted, Malad, against the petition, Malad, accused murder. But here, Malad, earlier no charge sheet, Malad. They have been not charge sheeted. Regarding 47, 48 notice also, Malad, in the case that it may be available, Malad, there are no grounds of arrest. But only on detention, Malad, 64 days, Malad.
Please take your.
Watch.
Let this matter along with AB 633. Two 2025. Tafozul Islam versus Alas Tafozul Islam versus State of Assam on 08042025. Rising out of
Oblige, your lordship.
Obliged. Meet please, your lordship.
There are other two, कितने cases? Yes.
10 and 11, same case.
I will hearing in item number 11. For two petitioner. Obliged.
Obliged. Meet please, your lordship. The sections which have been imposed are 22, 22C, 20.
Yes.
The sections which has been imposed on the petitioners are section 22C, 25 and 29 of the NDPS Act. Now I'm in custody since 6/10/2023. Already period of about 18 months is over in the meantime. But till date the charges have been framed, but the trial has not commenced. And secondly, I had no conscious possession, being the driver and the helper of the truck. On the fateful day, this truck was carrying certain consignments and we're carrying garments.
You are Mr. Vasudev Das.
Basudev Das.
Oh.
Basudev and another petitioner, Rahul Das.
Two petitioners.
Yes. One is the driver, the other is the helper.
Please take your.
Yes.
Yes, Mr. Sharma, what do you have to say?
My lord, here, uh, I have gone through the record, my lord. Here, another person was my lord, Iftikhar Alam, and as Aman, my lord. Against him, the split of the case, my lord, on 19/9/2024, my lord. And next date was fixed for, it was already over, my lord, 20th March, my lord, for consideration of charge, my lord. And regarding, my lord, contraband, my lord, they have concealed the, my lord, materials taken truck in the truck, my lord. 9,000, my lord, 9,000, my lord. Incident bottles, my lord. And it was from the vehicle, my lord. Six-wheeler vehicle, truck, my lord.
The petitioner chairing the driver and the,
Driver and handyman, my lord, helper, my lord.
it was booked by another person through that transport service.
My lord, yes, yes.
Tell us, that is why should not we consider bail of the petition?
My lord, here, section 37 will come, embargo of section 37 of the NDPS will come, my lord, as it is the commercial quantity is nature, my lord. And charge is yet to be framed, my lord. Only for 20th March, my lord, just for consideration of charge, my lord. Charge is yet to be framed, my lord.
Mr. Dr. Sarg has been framed or not?
No, it has not been framed.
When is the next date?
Next date is 3/4/2025. 3/4.
Everyone.
3/4. Yeah, then,
When it was split up,
My lord,
only both the cases were split up because another accused could not. be
my lord,
arrested.
that is 19/9/2024, as per order, my lord. I have taken my lord. Red color tag. 19/9/2024.
We'll fix it next week. Let that charge be payment. We'll consider. Just tell us, Mr. Dutta, whether any councils have been engaged by them and we aware.
In regard to the
Because what they have done in the month of
withdrawn the color now,
in February 2025, 7th of February, both the petitioners have withdrawn the Okalat number.
I'll take instruction.
And thereafter, they have not
Engage in it.
engaged any council. So on after 7th of February onwards, the matter continued like that up to 7th of March. Though on 3 dates, it was fixed for consideration of charge. And let us know. We'll have it next week. Give us a date.
And next week.
Your lordship, 7 on Monday.
Just 8.
8.
Okay. Third, Mr. Siddhant, that's Dr. Council appearing for the petitioner, investigation. The prayer of the council for the parties listed on 8th of March. And now both council for the petitioner as well as the prosecutor to apprise the court about the status of framing of charge against the petitioner. Fixed on Ivan 4th of April. In
Lordship may also,
issue will be at NDPS case number 131 of 202.
Lordship may call status, appeal status for registry, my lord.
It will take time.
My lord.
We get it, don't worry. But also indicate you. Yes.
Obliged.
Regular bail application, my lord. FIR at page 9, my lord. Yeah, my lord, 60 days total, my lord, and today 42 days from the date of forwarding.
Recovery.
Recovered, my lord, some cigarettes of gold plate.
Wait for 60 days. Why do you want to come out early? You'll be involved in the same thing again. How many? What is the forensic rate? Quantity?
Earlier occasion, lordship asked learned government advocate wallet to.
May I please allow me? I appear in item number 15, lordship. On the last occasion, lordship was directed the DRI lordship council whether they are imported, lordship, because it was evasion of taxes and already 43 days. Only on that query, lordship gave a date. Otherwise, lordship was satisfied about the case.
Yes.
Yes, may I please, your lordship. On last occasion, I produced the case diary. Lordship was inclined to ask if any other document is there or not. So I have get the instruction from the department. No new documents have been found during the investigation. Lordship, this is the current stage, lordship.
So the cigarettes, those are not foreign cigarettes.
Lordship, as of now, nothing has been found regarding that. And the onus of proof is on the petitioner side to prove that they are of foreign origin. Or
You have sent it for your FSL. You got it from, I think so, Karimganj or something like that. You have obtained the FSL. I think. It was there in, of course, not from Karimganj, somewhere in the.
In Jodha.
Is there-
Lordship, I have
there-
not,
It was from Kamrup.
case diary is not with me right now, Lordship.
Is there not with you?
Lordship,
With whom?
it's with the department. On last occasion, I produced.
Paper. Based on third for the after case there.
Lordship,
We'll have it the after tomorrow. What's the order?
Deeply obliged.
much of that.
Obliged.
Why are not having the case there?
Lordship, on last occasion, Lordship has asked me for the instruction that if any document has been
Doesn't
found
mean
or
you should
not.
have written because petitioner
Apologies,
saying
Lordship.
nothing in the day. Okay, look into it.
Lordship. Much obliged.
May it please your lordship. My lord, we have the records that have been called for by this honorable court. My lord, it was sent by both the department and the government.
Take your seat.
Where is Mr. Das?
My lord, he is unwell today.
His presence will be required, other the director's presence will be required
May kindly fix a date.
tomorrow. If, see, basically, we want the director. If Mr. Das can do the needful, fine. And that is why we look for the record. There are certain effects. You can note down because we are not parting with the record at this moment. You can note down. See, basically, the court by order dated 23rd of April in WPC number 1424/2011. April 15, directed to comply with the order within 4 months. Directing the Social Welfare Department as the nodal department. And that order was received by the Social Welfare Department on 1st of June 2015. You can note down the dates. Mr. Saika, you also note down the dates. WPC 1424/2011, that was the order. Order is of dated 23rd of April 2015. To be complied within a period of 4 months. That orders was never challenged before any higher forum. Social Welfare Department received a said order on 1st of June 2015 and was directed to put up immediately. The government in the Social Welfare Department on 12/8/2015 sent its letters to the Labor Department and also the Director of Employment and Crafts Training. And on 21st of August 2015, the Directorate of Employment and Crafts Training received the said order of the High Court, whereby there was a specific direction to apprise the Social Welfare Department about the existing vacancies reserved for physically handicapped category of grade 3 and 4 within 25th of August 2015. And the Director of Crafts and Training only on 7th June 2018 and 21st June 2018 submitted the vacancy. Because on 7th of June, after the contempt proceeding, the government in the Skill and Employment Entrepreneurship Department wrote to the director. Initially, WhatsApp message was given on 7/7/2018. Through WhatsApp, the joint director submitted the vacancy position. And then the government in between, something else had happened. 18 February 2017, the Director Employment and Crafting forwarded the vacancies because the government asked for it on 15/12/2016. Now just see, the vacancies were there available because the letter It was received by the Directorate of Employment and Corporate Training on 21st of August 2015. Immediately thereafter, vacancy position was shown. It was submitted on 28th of August 2015. By letter number DET, within bracket capital E, dash 111/2015. But nothing had happened. Only after the order of the contempt in 2018, he was appointed. So for the delay on your part, when the direction was given that to be appointed within 4 months, you have appointed after when? After how many years? So the director of the craftsman will also bring in the government. They have to, why not? Had this order been complied with in time, it is not that you are not aware of the order, that this record shows that you have received from the Social Welfare Department on 21st of August. You have communicated the government. In spite of that, you have not done anything. So tell us. Petitioner husband's name was Prafulla Burman. And on 31st of December 2015, the Labor and Employment Department directed you, the Director of Employment Classment, for appointment of this Prafulla Burman in grade 4 post after the letter that you have sent on 28th of August 2015 pertaining to the vacancy. But you have not appointed. How Mr. Das will explain this? These are on record. Right? So what do you expect the court to pass an order? In fact, when this, prior to filing of this application, when this writ petition was filed, we have asked you to comply with the orders on the basis of certain letters that it has come to our notice. We did not indicate. We thought that your good senses will prevail. Why we have passed that order, right? After all, the court, they have to certificate judiciary, so we do not pass simply an order for that purpose. We have seen somewhere in that tons of documents, and that is why we have, since you have not been, you have not complied with. Yes, you have a right to go for an appeal. You have done for an appeal, and it was matter sent back. And this time we are not leaving you. The reason is very simple, because in that letter, that particular bunch of documents that was placed before the court, there was sufficient material. Right? Had that order of the learned single just past study would have been challenged, things would have been different. That was not challenged. That 4 months period remained intact. And you have all these communications. An interesting 31st of December 2015, there is a specific direction for appointment of the late husband of the petitioner. And wonderful, you see, this has the approval that the Honorable Chief Minister will place everything. Now you do not want to pay to the pension to that lady because he did not complete 1 year, right? Whose fault it was? When the Labor and Employment Department in the government of Assam on 31st of December 2015 specifically indicated that it has the approval of the Chief Minister of the state. for appointment of the husband of the petitioner. They did not appoint him till 2018. Why? Will you able to answer? Not you, I'm talking to your department. So that is why probably we'll be requiring your commissioner, secretary and director to answer. When they shall appear?
Fix a date.
Person to the order. Dated 28/02/2025. Passed earlier in this process. Relevant records have been placed before the court. That will stop. From the commissioner, secretary, skill, employment and internal department. The directorate of employment and craftsman training. Records of the case. Only on perusal of the records of the case. It is seen that a Social Welfare Department of the state on 01/06/2015 received the order dated 23/04/2015 passed by the coordinate bench of this court in WPC number 1424/2011. Wherein the husband of the present petitioner was also a petitioner amongst 106 petitions, in which the court, by the said order, take your seats, 23/04/2015 directed the Social Welfare Department, being the nodal department, to verify the position of the petitioners pertaining to this selection and appointment of persons with disabilities act, vis-a-vis the selection process, and proceed with their appointment in terms of their position, directing further to complete the exercise within a period of 4 months from the date of receipt of the certified copy of the said order. In bracket, order 23/04/2015, first number 1444/2011 and the state government in labor and employment department, no, state government in the social welfare department after receipt of the said order on 01062015 by its communication number SWDU.146/2011/222 dated 12/08/2015, directed the labor department of the state to accommodate 14 numbers of petitioners. To accommodate the petitioners in the concerned vacancies. On receipt of such letter from the Social Welfare Department dated 12/08/2015, the state government and the Labor and Numerical Employment Department by number GLR.156/2015/17 dated 20/08/2015, amongst others, directed the Director of Employment and Craftsman Training, Assam, Guwahati, to furnish the existing vacancies reserved for physically handicapped category for grade 3 and numerical and 4 in the said establishment within 25/08/2015 positively, treating the said case to be most urgent. On 29/08/2015, the Labor and Employment Department, the State Government Labor and Employment Department, by number GLR.156/2015/18, issued a reminder to furnish the vacancies of grade 4 and grade 3 under physically handicapped category on or before 31/08/2015 positively. Pursuant to the same, the government of Assam in the Labor and Employment Department, after obtaining necessary vacancies for filling up of necessary vacancies of differently able persons, White communication number ZLR.156/2015/35, dated 31/12/2015, directed the Director of Employment and Craftsman Training, Assam, to take necessary action as per the Finance Department's Office Memorandum Number FSI, all capital, -5, /2005, volume UL dot dash capital Roman 6, /76, dated 30/03/2012 for 2012 for appointment of 3 specially able persons in the grade 4 category, including the husband of the petitioner, by following all norms and procedures, with an intimation to the Labor and Employment Department, indicating that the same has the approval of the Honorable Chief Minister of the state. And a copy of the said letter, dated 31/12/2015, was also forwarded to the Additional Chief Secretary, Labor and Employment Department, as well as Deputy Secretary, Government of Assam in the Social Welfare Department, for compliance of the order of the court dated such and such, such and such. However,
We have to verify the records again. There are some other letters have cropped up. It'll take time. We'll fix them fifth. List them fifth. बाकीখিনি मारी थोड़ा. बाकी order नहीं fifth. When he was appointed, Mr. Saikia? When he was appointed?
One 2019.
So let me verify the record. Come back to you on fifth.
And next be page number 22 in my repetition notice, that is the appointment order.
Come back. Let me go through the records. There are certain other documents that needs to be verified. This one, fifth. We do not know what will happen on fifth. The outcome.
Yes, ma'am.
We'll see only after perusal of the record.